Morning. Thank you again for joining us and choosing to start your morning here on the 2nd of April with us here at NTV Uganda. We're getting into our Kickstarter conversations and the first of the many that we have for you this morning. We shall start with embracing the alternative dispute resolution as a case management tool in dispute resolution. Now, pretty much court annexed mediation mandated by the Judicature Mediation Rules of 2013. This particular process uses neutral third parties to help disputants reach voluntary agreements, which then become court judgments. And under the ADR, you look at this particular and being supported by Article 126 2E of the Ugandan Constitution, which encourages reconciliation, and the alternative justice system AGS strategy of 2023. Now, we understand the relevance of this inclusion to the judiciary, and in that regard, we're going to be speaking to His Worship James Eremye, spokesperson of the judiciary. A very good morning, sir. Good to have you.
Yes, good morning. And once again, our viewers, we love you so much, and thank you for joining us.
Well, and indeed, we are glad to be having you. And next to be Her Worship Justin Asma Atukwasa, Registrar, ADR, Judiciary. Good morning.
Good morning to you. Good morning, viewers and listeners. We are glad to speak to you, and we love you so much.
All right. Let me take this direct to His Worship James Eremye.
Yes.
If you're to talk to us about the alternative dispute resolution, the ADR, and why this particular one, how important is it for the judiciary, and how important is it in serving justice and law in the country?
Oh, thank you so much. I bring you greetings from the Honorable the Chief Justice, and I want also to congratulate and inform the public that the Honorable Chief Justice on Saturday last week, he launched the Judiciary Bot, which is a facility intended to facilitate the administration of justice for island communities. And I want to congratulate the people of the Sese Islands, Karangala in particular, and we ask them to please keep that equipment very well, because it is intended to enhance access to justice in that area. And on another note, the Honorable Chief Justice, exercising his powers again, under Article 133(1)B, he issued a legal notice, which is legal notice number 1 of 2026, the Constitution, Operation of Mobile Courts Practice Direction. It's intended also to enhance access to rural communities, and in places where we don't have infrastructure like buildings, but we can have our judicial officers and other stakeholders to go and do their work and serve the public. Those are the commitments that the Honorable the Chief Justice is bringing up, and innovations to ensure that we have a seamless administration of justice. Now, to come to ADR, ADR as an acronym, it is Alternative Dispute Resolution. And alternative in a sense that we have the formal mainstream adjudicatory mechanisms where you bring your case to court and then you have to file witnesses, etc. It's adversarial in a sense that you see you are seated and arguing law, facts, etc. The judiciary, recognizing that alternative mechanisms are available that will enhance and even speed up trials, which will bring parties on board, which will help parties appreciate the case without going into the longer processes of court, that then the judiciary comes in to revamp and bring up a robust approach that will enable parties, when we come to court, as a judiciary, the Honorable Chief Justice has made a direction that all matters must undergo ADR. Here, let me speak to mediation, for instance. There are other forms of ADR, but now for mediation in civil matters, you have a case in court, we want to sit with you, give you court-accredited mediators. These are very specialized people. They are skilled, they know what they do, sit with you, take you through your case. And before you know it, we have reached a consent. One has understood that they were in the wrong. One has understood that this legal provision or the other does not favor their interests, etc. We reduce on costs, we reduce on time leads, we reduce on complaints, we reduce on so many things. So ADR and now onboarding with the African justice mechanisms is the way to go. And as a judiciary, we have taken keen interest to ensure that we sensitize the public, to bring them on board, to appreciate that in case management, there is no better way than through ADR. And ADR has enormous advantages which, if embraced, we shall see ourselves having expeditious trials, because you don't have much time to waste. Number two, we don't have to spend too much money in terms of costs, in terms of legal representations, you reduce those ones. Number three, complaints that, everyone who loses a case thinks that because there was some element of corruption or abuse of office, But here, everybody is on board, and we are saying that's the way to go.
All right. Hawaship, when you look at alternative dispute resolution in the judiciary, particularly in Uganda, it's looked at as a core justice strategy used to reduce the case backlogs, cut costs, and expedite disputes. And is this coming to fruition for the period it has been used and its implementation so far?
Thank you very much. As you may know, I was adding from what he has said. If I give you a small statistics, that the judiciary, as of the court case census 2025, had 167,000 of workload. 70 in the High Court, 64 in the magistrates' courts, and 30 pending in magistrate grade 2 courts. Now, this is against the backdrop of less human resource of only 88 High Court judges, about 500 magistrates. Now, since 2013, as you said earlier, the judiciary institutionalized ADR, mediation and plea bargaining in 2016, and along the way we didn't achieve as we wished. But come 2024, the judiciary has gone on the road to revamp ADR. And if 2024, in the year 2025, we did an assessment of the performance of ADR. In 2025, mediation alone delivered 5,226 cases in the year 2025, and plea bargain delivered 3,000 cases. And so this is in a very short time. When we did the costing, the cost of a case, civil, there has never been such a research on civil matters, on the cost of a civil case through a full trial. But when we costed it, it was about 176,000, which is very rare. And in a plea bargaining criminal was about 500,000 a case. And if you see plea bargaining, if handles a matter in minutes, one plea bargaining case can be handled in a minimum of 20,000, of 20 minutes. Now, ADR is performing wonders. If we continue on this road, we are sure, and as you are aware, the nation now has an ADR policy of 2025. And the mission is to have a society free of unresolved disputes. So ADR is such a tool that we cannot ignore. It's not less of any access to justice. It is just one mechanism that is going to help us to have our society resolve their disputes. Okay. As he said, in time, with less cost, and to restore relations among the disputants.
Okay, and Hawaship, still with you. One of the major expectations the citizens in the country have of the justice system is timely justice. So when disputes take an excessively long time, you've got to realize that a number of negative consequences arise in regards to the criticism the judiciary faces, the public outcry, and how the public view the work of the judiciary. What is the current status of case fastness in this current system? when you were to estimate performance per quarter?
The performance per quarter judiciary in the year 2025, according to the court case census, had we delivered 48,000 cases.
Okay.
Per quarter, that would mean 45,000 cases by quarter. That is not with my report. Let me.
No, but we could go with only the numbers for now.
48,000 cases.
So is there an improvement?
About 12,000 cases per quarter. Certainly there is an improvement because of ADR.
Okay.
Yeah, there is an improvement. As I said, of the 48,000 that were delivered, ADR was about 4.7% of the performance. And so if you take only the numbers, it may seem as a smaller percentage, but ADR reduces on the workload that goes to the appeals, because through mediation, through plea bargaining, there are no appeals, very minimal appeals that go to the Court of Appeal.
Okay.
And therefore, the improvement may be not only in numbers, it drops down to the cost and the other processes in the higher courts.
And His Worship, let's get to you in regards to the adoption of technology and what effect it has had on the implementation of good judicial services for the Ugandans, or the expected judicial services for the citizens.
Okay. First of all, in the last Judiciary Strategic Investment Plan 5, one of the key items that the judiciary was looking forward to ensuring we achieve in the transformation agenda was the use and implementation of ICT. In our SIP 6, the Honorable Chief Justice Dr. Flavian Nzeja has emphasized that he's going to ensure enhanced improvement in the use of ICT in the delivery of judicial services. People will be informed that we are now rolling out ECMIS. ECMIS is an ICT-based solution to case management. E-filing, for instance, where you just need to stay in your home, and if you have a computer and internet, you can file a matter in an ECMIS court. And that ICT solution has gone a long way to reduce on costs incurred by advocates and parties having to go to court to file matters, including even production of paper, pleadings in court before the innovation of ICT in our courts and our e-governance. We would have to bring a set of papers. Now imagine now, like these election petitions, they are so voluminous. Now, producing one set of pleadings will require a lot of cost. Yet in an ECMIS court, you have everything electronic and you can submit it there. We are also moving other areas of innovation in ICT to do with video conferencing. We don't need people who are in the diaspora, for instance, or outside the country, or even far away from the court, if they can use technology to participate in proceedings in the court. That is video conferencing. We are also ensuring that even inmates who are in remand places, for instance in prisons, due to so many other factors including security concerns, and also of course the cost of producing them in the courts, wherever they are. We are having Ruzira. Ruzira is very near here, okay? But I'll tell you the cost of producing an inmate supposed to appear before a court from Ruzira to Buganda Road Court, that cost is so enormous. Okay? So ICT technology have come in handy to see to it that we mitigate some of those costs.
Okay.
Okay, and that is the way to go. And also other areas. So we are using video conferencing, we are using AKMIS, and we are going to continue using, now we have also what we call the performance enhancement tool. It's also a web-based tool to enhance performance of judicial officers and non-judicial officers in the judiciary. And it's a matter of great concern today. Okay. We are looking at how do we improve and enhance the administration of justice. Using technology.
All right, yes. Thank you very much, James. When you look at some of the situation to do with the alternative dispute resolution, let's look at it from the culture perspective of things. Case in point, the matter put system of Northern Uganda, a very good case study in regards to the same. How have communities, have you engaged with communities and different cultures and embedded some of their, how they deal with some conflicts to what the judiciary wants to address?
Before I talk about that, I would like to say, as earlier, that through plea bargaining, one of the ADR mechanisms, last year, reconciliation, for the first time in the country, the convicts, the number of convicts in prison were higher than remands because of plea bargaining, because we asked about the advantages. Okay. And the convicts were 53 and remands were 45% of the prison population. Okay. Now, the question you have asked falls under the alternative justice systems. As you earlier said, the judiciary has the alternative justice system strategy 2023. And in order to engage the communities and to ensure that the informal sector comes along or speaks together with the formal judicial system, we have engaged the communities. Last year, December, on the 17th, we launched in the Acholi Lango region the AGS in that region, and the number of resolutions were made, and we are planning back to make sure that we go back and have those resolutions implemented. Okay. We have trained a number of communities, religious leaders, religious institutions. We have trained agricultural leaders to skill them to make sure that they are able to handle disputes in the communities. And as a judiciary, we provide a supervisory role. Okay.
And when you look at the impact this is going to have on our justice system in its entirety, what do you have to say about it?
As you may know, research says that 90% of disputes are resolved in the communities, not in courts. And so we look forward, as I told you, under the ADR strategy, to a community free of unresolved disputes. Okay. One, it is going to help the society have easy and quick access to justice. Okay. It is going to help our communities to reduce drastically on the cost of litigation. It is going to help our communities to restore relations. The major advantage of ADR that it may be unseen, as you said, talked about Matokot, is restoration of relations. That cannot be provided for, or it cannot be got through adversarial litigation. Okay. Because when the parties sit and negotiate, when they sit and mediate and talk, by the time they leave, first of all, they have an agreement for which both respect. So they will not go for appeals, they will all go satisfied. Beyond that, sometimes a party is only looking for an apology. And so that apology alone will make the people still live together in harmony. Okay. And
now let me get the parting shots. I'll start with His Worship, James Remy. As we're embracing ADR as a case management tool in disputed resolution moving forward, what should law practitioners, the community do to be part of this journey with the judiciary?
Thank you so much. First of all, it's the commitment of the new Chief Justice, Dr. Flavian Nzeija, that he will ensure that ADR is part and parcel of our court system. Okay. And I want to inform the viewers that Uganda is actually hosting the African ADR Forum.
Okay.
We are the champions on the African continent. We have had many visiting Chief Justices from different jurisdictions coming here to even benchmark and discuss ADR. And many resolutions have been undertaken to ensure that we champion ADR. Now, to our viewers, ADR is the way to go. It has enormous advantages, including reduction in lead times, including reducing the cost of litigation. You have heard our people complaining of cost of litigation, instruction fees to lawyers, transport, etc. ADR addresses those concerns, and of course, we are reducing the adversarial approach to this kind of work. As a judiciary, we are committed to ensuring that every other day we come up with innovations that are intended to improve and enhance access to justice. Our viewers, the public, advocates, members of the bar, we would want that you take this innovation very seriously, educate the parties in matters that you have brought before court, and we believe together we shall achieve improved access to justice. Okay. The vision of the judiciary is justice for all, and all interventions that we come up with are intended for the benefit of the public.
All right, thank you very much. Her Worship, in just a few words, your parting shots.
In parting shots, I would first of all encourage the public to resolve disputes outside court. Okay. The court is loaded with caseload. We would be very happy when you find the means using these ADR mechanisms to resolve your disputes outside court. Go to your community leaders, the church leaders, to make sure they help you resolve your disputes. And we would encourage the advocates to encourage their parties to go outside court, even with the cases in the court, to take them through the mediation, if we are criminal plea bargaining, to ensure that we resolve the disputes quickly and we help our country raise the GDP.
All right. Indeed, there you have it, embracing the ADR as a case management tool in dispute resolution. My two guests this morning, I've had His Worship James Seremier, spokesperson of the judiciary, and I've also had Worship Justin Asma Tukwasa, Registrar ADR Judiciary. Thank you very much, gentlemen and lady, for giving us your time this morning. Stick around 2 more.